Hello, and welcome to the Certified HIPAA Privacy Associate Training course. The purpose of this training is to provide an overview of the Health Insurance Portability and Accountability Act, known as HIPAA, the high-tech amendment to it enacted in 2010, the omnibus rules issued against it in 2013, and the provision of each of these that has had such a great impact on the healthcare industry. This training is specifically intended to describe in detail the privacy and security requirements incorporated in these regulations, and to define the related actions of a certified HIPAA privacy associate in order to successfully achieve compliance with them. So let's begin. The Health Insurance Portability and Accountability Act was passed in 1996 and enacted a year later. It was intended to bring a great deal of portability and continuity to the health care insurance that workers would typically have with their employer and give them the ability to take it from one coverage and one employer to the next. Title I of HIPAA protects this right and this ability to take their insurance with them. Title II of HIPAA, called the Administrative Simplification Provisions, require the establishment of the national standards for electronic health transactions and the national identifiers for the various parties and purposes associated with it. Slide 3. Title II also requires the implementation of appropriate privacy and security practices related to the use and disclosure of protected health information. The two basic parts of this are popularly known as the privacy rule and the security rule. Slide 4. So the provisions apply to all covered entities, which include health plans, healthcare providers, both individuals and institutions, and a unique middleman sort of operation known as a healthcare clearinghouse, which we'll discuss more later. These provisions were expanded with the passage of HITECH in 2009 and its enactment a year later in 2010 to cover a group known as business associates. This includes both the privacy rule for use and disclosure provisions and the complete security rule. In 2013, the omnibus rule was passed by the Department of Health and Human Services, and it clarifies and gives guidance for the implementation of HITECH. Slide 5. Going back to the original HIPAA, it turned out that it was one of the most sweeping privacy laws at the federal level ever passed in the United States. Its intention was to provide strong privacy protection for healthcare information without hindering the delivery of quality and timely healthcare. The group defined as covered entities and the group defined as business associates were required to perform a number of actions, including a thorough review of their privacy practice, gap analysis, and then take appropriate steps to close those gaps and apply the controls necessary to ensure that the entity was in compliance with HIPAA. Slide 6. Now what the privacy rule covers is a number of things, but to begin with, it gave individuals, the patients or the subjects of the information, a great deal of control over their health information. It also set boundaries on the collection, use, and disclosure of this information so that covered entities could make use of it in ways that were appropriate to the treatment and payment processing for the treatments given to the patients, and also it set up some guidelines and some controls for business associates as well. It required the establishment of policies and procedures and ensured that what was put into that documentation was also put into active practice so that what was on paper was also being performed. And it meant for us to document all of the practices that we had with regard to the protection of privacy. In accordance with all of this, it established guidelines and metrics for accountability and to identify and investigate violations with both civil and criminal penalties. Slide 7. So, all of this information about patients that we keep calling PHI, what is actually covered? What are the contents that make this up? The privacy rule protects health information that clearly identifies a specific individual and that in the course of providing healthcare and processing for treatment, it is used and disclosed by a covered entity and their business associates. It includes both physical and mental health records, and all other was called individually identifiable health information, which is what we commonly call PHI, regardless of the form that it takes. And all forms, including electronic, paper, or spoken, are covered by these rules. Slide 8. In the course of using this information, there are times when we have to disclose it. There are times that we have to share it with other entities or individuals. So it set up this doctrine that we now know as minimum necessary. It is a very fluid definition, but the idea is that you release just enough information to satisfy any particular need or requirement or request. So it basically comes down to whatever it takes, but given some thought, given some analysis to the type of job or request that's in front of you, it takes just enough to get the job done or respond to the request. The idea is that we don't overexpose patient information in quantities or types beyond what is truly the minimal necessary. The fact is, it could be the entire medical record, as it often is in the case of treatment. Or it could be just a discharge summary in other cases. But whatever the case is, we should always try to look at whatever the least amount is that's necessary to satisfy the particular need and release that. Slide 9. There are, however, times when minimum necessary doesn't apply. Disclosures or requests by providers for treatment purposes clearly would require the release of the entire record. Doctors treat patients as an entire being, in other words, in a holistic sort of way. To deprive them of any information, of course, might cause a problem with that treatment, so we release everything that may be necessary. There are times when disclosures to the individual who is the subject are to be made, in which case we release all that the law allows, which is all of the medical or physical medical information and claims history, but not the mental records, which we'll talk about more later. Then there are other times when there is an authorization in place that describes and limits the amount of information to be released. Then we are bound by whatever the authorization is given by the individual or the individual's designated personal representative, someone who has been assigned the authority to act in the patient's behalf. This could be either a court or it could be the individual themselves through a power of attorney. Slide 10. Minimum necessary also does not apply when it is part of the HIPAA standard transaction set. The way that this comes into being is that the information required to complete the standard transaction and prepare it for delivery and adjudication constitutes the minimum necessary in that particular transaction. Whenever HHS needs to investigate or enforce the rules or follow up on a complaint or perform an audit, this too is a time when minimum necessary does not apply. And then, of course, in the law, there are various ways and means that it describes that the PHI must be disclosed pursuant to special reasons that the law itself identifies. Those particular uses of disclosures that are required by the law and written into it also set aside minimum necessary. Slide 11. Now, the vehicle that we use to notify the patient of all of their rights and various other very important information is called the Notice of Privacy Practices. This notice provides a general explanation of the individual's rights that come to them under the HIPAA privacy rule. Then it goes on to summarize what the covered entity's privacy practices are. It provides a short description of how and when the covered entity will use and disclose the PHI, as well as outlining specifically what the individual's rights under this particular law are. Slide 12. Now, one of the things about this notice, of course, is it cannot be written in legalese. It must be written in plain, easy-to-understand language. Now, having said that, there is no written requirement that it be in more than the single language of English.